Whakataka te hau ki te uru, whakataka te hau ki te tonga, kia mā kinakina ki uta, kia mā tarata ki tai, kia hi ake ana te atakura, he tio, he huka, he hauhu, ti hei mauri ura.
Tēnā koutou katoa, nā mai haere mai ki tēnei hui, ko Robert Scott. Good morning, everybody, submitters. Welcome back. This is hearing number 13. I think we last saw you at hearing number 9, the rural zone hearing.
Yeah, quite a number.
So look, I'll skip my usual long introduction because I'm quite familiar with the way that we run these hearings. We're at this is hearing number 13, which relates to hazardous substances and hazards, both two separate chapters in the plan. My name is Robert Scott. To my right, I have Councillor Boyd, and I had Commissioner Kensington. As you know, we have a hearing panel that will be determining these particular topics. We held deliberations once we finished the hearing, but we'll be delivering a complete set of recommendations. You know how to conduct yourselves, so I won't go through that. So we'll just get the housekeeping matters explained.
Sure.
Alicia can explain the housekeeping matters, and then we'll get right into the submission.
So we know where the bathrooms are. I'm sure you guys know where the bathrooms are, but if you don't, they're out the door and round to the right. In the event of a fire, we will get out fire exits and assemble on the lawn over that way, sort of by the memorial hall. We're obviously recording today's session. It will go online later today or tomorrow morning. Just so you know, although you can only see the chambers view on the screen, we have got this camera working, which is voice sensitive and turning towards. So when you guys are sitting here, for example, the camera will be you. Please make sure any devices are turned off or silent.
Okay. Now, council officers, we have Jerome White. Got your name right this time. You do a presentation that introduces the two particular chapters and topics. Are you going to give me that presentation?
That's the plan,
Russ. Okay, well then I'll hand it over to you.
Oh, this may or may not work, as you know. I've pointed at my laptop, and if it doesn't, I'll do it for you.
I'm sorry, Liz Morgan, you're going to do that.
Hazardous
Substances chapter. So which one you're going to go first?
So I'm going to go first.
Oh, sorry.
That's right.
Oh yes, of course. Here we go.
Yep. Okay. Yay.
So I am the reporting officer for hazardous substances. Just an overview of the topic. There were 13 original submissions with 48 submission points and 14 further submitters with 74 submission points. The submissions came from the oil companies, the power companies, the private sector, iwi, hapu and government agencies. So, yes, just to indicate the key issues raised, the submitters wanted some clarity around the definition of hazardous substances and the definition of significant hazardous facility. And I'll come to the changes around those two in a minute. There was clarity was sought around the rule framework, particularly from Top Energy, who opposed the rule framework. They sought that the Far North Council adopt what had occurred at Whanganui District Council. And that I will also explain to you in depth in a minute, and why I recommend that you don't adopt that particular framework. But in short, the issue was they thought that the function of controlling the adverse effects of the storage, use, disposal and transportation of hazardous substance no longer sit within the Far North District Council and sit really within the framework of the RMA, which is what Whangarei District Council have done. So if I can come to the recommendations, the oil companies sought a change to the definition of significant hazardous facilities, and I have recommended that their definition be adopted, and that is set out in Appendix 1.2 that's attached. And really what that is that they have sought that take me to my report, that is sought out at page 13 of my report. So that is a change of deleting the words HSNO code of practice and replacing work safe guidance. And that, in my recommendation, is appropriate and it is in line with all the other plans. FNDC submitted, including further detailed activities relating to the storage of hazardous substances. I did not recommend that be included. And my rationale for that is set out at paragraph 55 of my report. However, the most significant issue is really Top Energy's submission around whether the Far North District Council should adopt a similar approach as our neighbours in Whangarei District Council. And I've gone into some detail about that on page 22 of my report. And I'm happy to talk further about that. But in essence, what I did was I looked at other plans, and in my recommendation, Whangarei District Council is an outlier. And it's my recommendation that we follow other councils who have included a rule framework in respect of including rules around the storage and management of hazardous substances. I'm happy during submissions to talk further about that.
Yes, thank you. It might be an opportunity to have some two-way dialogue between you and the submitter once we heard their evidence. Any clarification questions? We'll save up some bigger picture questions for you until after we've heard the evidence. That give you a chance to consider them and come back as your response. But is there anything you want to clarify?
Just two very minor clarifications from me, thanks. Just in terms of the numbers of submitters at paragraph 2, 13 original submitters and 14 further submitters, and then as along 43, got a different set of numbers there. Is that the paragraph 43 numbers, are they incorrect? And we should be looking at the paragraph 2 numbers.
Can I come back to you? It might be a typographical
I
error.
think it might be a typo. I think it's paragraph 2 is the correct one. Just wanted to
I'll come back to you.
And then also paragraph 13, I think it's a typo as well, which might refer to a different topic. It says there, these submission points will be addressed as part of the rezoning hearing.
Oh,
But I don't think we've got any
no,
rezoning matters here, so whether that needs to be struck through.
I will. I'll come back to both of those and actually need to read it after the break.
Okay, thank you. That was all right.
Okay, great. Thank you for that introduction, Mr. White.
So good morning, Chair and Commissioners. I'm going to provide an overview of the natural hazards chapter in terms of some of the key issues in submissions and my recommendations. So in total, there were 321 original submission points on the natural hazards chapter and 514 further submission points on those submissions. And those submissions primarily came from private individuals and landowners with land affected or potentially affected by natural hazards, planning and engineering firms, infrastructure providers, including telco companies and Top Energy, who you will hear from today, central and local government organisations, including NRC and Ministry of Education, and primary sector submitters, including Federated Farmers, who you'll hear from today.
Quite a powerful image you've got up there.
Yeah, you all know what that is.
Over here, Jerome. Oh, yeah.
So there's a bit of detail on the screen there. In general, there's support for the sort of risk-based approach that's central to the natural hazards chapter. And I'm recommending that's retained as best practice, and it's consistent with higher order documents, including the National Policy Statement for Natural Hazards, which is being consulted on at the moment. Generally, many of the objectives and policies were supported, and I'm recommending that these are largely retained with some minor amendments that are consistent with the overall intent, such as including references to vulnerable activities in Policy 9. Some concerns that the policies are too specific and directive, in particular Policy 6 and 7. My recommendation is retain those. In my view, it's clear and specific policy direction is a good thing, not a bad thing, and those policies in particular give effect to some specific requirements in the RPS. Probably one of the biggest themes was some concerns about some of the permitted activity thresholds are overly restricting for buildings and structures and infrastructure, and identified river flood hazard areas and coastal flood areas, which are both mapped in the plan. I'm recommending some minor amendments to allow for some small increases in the existing footprint of infrastructure and buildings, more for consistency. But otherwise, I'm recommending those thresholds are retained. They're not saying development can't go ahead, they're more saying they're acting as an important threshold for a more detailed risk assessment. And also to recognise that you're increasing the size of buildings and hazard areas, you're generally increasing risk, and that's contrary to the general direction and the objectives and policies. And further, there's been no evidence or provided submission around more appropriate thresholds, and these thresholds are based on the use of other plans. Some concerns raised about the rules for river flood hazard areas and new buildings, and that was unclear. So I recommended amendments to Rule 7 to clarify that the relationship of the rules. Also deleting Rule 12 because that became somewhat redundant. Some submitters raised some concerns that the coastal hazard rules duplicate, which is correct. And I'm recommending 2 rules in the coastal hazard rules are deleted, and they relate to hazardous facilities in coastal hazard areas. So,
I'm just like, I'll do it.
oh, gone too far.
Oh, sorry.
You go. The next issue relates to the approach for wildfire risk. So there's sort of 4 main hazards that are addressed in the plan. So there's river flood hazard areas, coastal hazards, wildfire risk, and land stability. Generally, the intent of these rules are supported, but there's concerns that the sort of 20-metre setback to existing scrub can create unnecessary consent requirements. I'm recommending some amendments to those rules, really with the intent of improving workability, so that 20-metre setback only applies outside urban areas. Recognise that sometimes you can't really locate your building away from existing vegetation over the fence, and amending the requirements that relate to water supply for firefighting purposes and complying with the Fence Code of Practice. They're more specific for articulated and non-articulated areas. The next issue relates to the approach for land susceptible to land instability, which is a new approach for the PDP compared to the operative plan. Again, general support for the intent, but some concerns about workability. I'm recommending the general approach is retained, which is to assess land stability at the time of subdivision, and a minor amendment to the definition of land susceptibility to land stability to address a workability issue. Numerous requests to better recognise existing use rights throughout the provisions. I'm not recommending the response in relation to that. It's not appropriate or necessary to duplicate Section 10 of the RMA, in my opinion. And lastly, there's a range of concerns from landowners about the mapping of natural hazards on their property. In response to that, we commissioned Tonkin and Taylor, who have done a review of those from a technical perspective, and that's attached as Appendix 3 in my evidence. The general conclusion of that review is that the mapping of the PDP is appropriate. It gives effect to the RPS, the methodology used are appropriate, and or there's insufficient information in those submissions to amend the natural hazard mapping. And lastly, there's 2 more nice images for you. As you'll be aware, there's been limited relatively limited evidence received on the natural hazards chapter. What has been received from federated farmers, fuel companies and key rail generally support. In terms of the outstanding issues, you'll hear from the telco communications that they want the sort of exemption or permitted framework for telecommunication facilities to be expanded to go beyond telecommunications facilities regulated under the NESTF. And again, there's amendments currently up for consultation on the NESTF, which will expand their coverage into other zones. Top Energy is reiterating the request for a new objective specific to existing infrastructure and identified hazard areas. Foodstuffs and flexibilities have essentially reiterated their concerns about the PA thresholds being too overly restrictive without providing any tangible solutions, in my view. Flexibilities is also seeking exemption for certain rules for the heavy industrial zone to sort of recognise that you generally don't like locate sensitive activities there. And lastly, Top Energy is seeking some further refinements to the information standards, so that making it clear they only apply mapped areas and to remove the requirement of engineers to assess objectives and policies. And I think that's me. Thank you.
Great, thank you very much. Obviously, there are a couple of tendrils that reach back to previous topics and obviously the coastal section. So every time we think we've addressed all the issues with hearing 4, it comes back. It seems to me that obviously those chapters, have far-reaching tendrils into other chapters, and this will happen again. So we understand that and how that relates back to the coastal chapter. And we'll look at that carefully. And then the other chapter that seems to be popping up a lot is the subdivision chapter. Who's going to be reporting on that chapter?
Mr. Chair, that will be, we recognise the complex and integrated nature of the chapter, so there'll be a range of people inputting into that.
I was going to suggest it looks like it might be a team effort.
Absolutely, yeah, no, that's certainly what we're working through. We're well aware of the complexities of the chapter.
That's hearing 16, which sounds like a long way away. But
yeah.
all the rules, like the subdivision rules that are specific to natural hazards, they'll be allocated to each topic before that was most appropriate, but there's still going to be a need to come back together.
Yes, I think there's going to be a lot of knitting together of those interrelated provisions, but that's the challenge before us. Well, thanks very much. I think it's become the trend that we have a lot of submissions, but we don't get a lot of evidence. It's becoming obvious to us that's a tribute to the quality of the 42A writing. You've addressed all the submissions in quite a lot of detail, and some reasonably well-resourced submitters have determined either to file evidence and not appear, or there are just a few matters that need to be resolved that are in contention. So I think it's a measure of the quality of the 42A writing that submitters can feel that most of their issues in contention have been addressed. Well done. Certainly making our job a little bit easier. We got any questions or clarification?
Yeah, I had a question about the mapping from Northern Regional Council. So you'd be aware there's a process under the Building Act when people apply for building buildings within a hazard. And currently the maps from Regional Council, the most recent maps from Regional Council utilised as part of that process. The updated maps are to be included in the new district plan. Some of the questions that we've asked from to the Regional Council Hazards team are about how accurate those maps are. In particular, for coastal hazards, the question was raised about the geomorphology, so the actual type of soil or rock that will be eroded or not, and has that been considered by Regional Council in their mapping? And in their meeting with the NRC, they said no, they hadn't done that work yet. But they seek to have more information about hazards and getting better data as they progress. I think they said the last time they'd updated their mapping was in 2021. Do you have any information on that? Because I'm not sure that applicants know how we get these maps, and that data is actually not from us, it's from NRC. But we are essentially the voice of that data, and it can impact if people can get insurance or not, or build a house or not without restrictions. It's quite an onerous layer. They do have that.
My understanding is that the PDP maps are on the best, based on the RPS maps at that time. There's always going to be new information that comes to light around hazards. That means that, that information may seem outdated. I guess the thing is these mapping doesn't say you can't do anything necessarily. It says there's a risk of a hazard here, and then acts as a trigger for a more detailed assessment. So yes, that's my response. I haven't been part of those conversations you've had with NRC about the geomorphology and how that's incorporated into the plans.
Just give us 2 seconds on that. We might further respond to that, Mr. Chair. I think there was a discussion with Tonkin and Taylor about underlying geomorphology and how they section up, particularly the coastal erosion areas, for their assessments. My understanding is that they do, but we might provide some further information on that at a later date or clarification from somebody on that. Yeah.
And just further a question about the mapping, NRC detailed in the questions that we had about flood hazards, there is a process that landowners can go through in order to provide more clarity about their site, in order to get that line moved, essentially proving they're not in a flood hazard area, even though the current mapping shows that. But they said that that was the only hazard that they had that process for, but they were looking to have pathways so that more detailed information that was site specific could be provided, so that those lines could be moved. In terms of them updating their maps and changing those lines based on site-specific information that landowners can provide, is that process able to be moved through into our district plan without a full Schedule 1 plan change? We have to do the whole process.
Any sort of changes to the provisions or the maps requires a Schedule 1 process.
And they have to be a statutory. They have, they have to be in the plan.
Yeah.
They have to be in the plan.
I guess the question is more around the new Remain framework that's coming up, and that national direction around natural hazards. So I think previously we adopted our previous operative plan in 2007, partly operative, and then we didn't have our, these plan changes, this new plan. So that's a long time with having plans attached to your district plan that had more updated information for hazards. So I guess moving forward, that will be something that will be quite topical, I think, given the changes.
Mr. Chair, look, I think the onus is on council to fund these updates as and when appropriate. When these land, officers will, and I would imagine there'll be discussions between the 2 levels of governance anyway on the matter, but the council will need to be funding plan changes to update these. Probably question for probably the political arm.
Yeah. I mean, looking at other jurisdictions, some council, Auckland, for example, they have their hazards mapped as a non-statutory layer. They have rules in their plan that said where you have a flood area, and then they leave it up to this non-statutory layer, which is dynamic too. And they've literally just updated it where since, and so the flood levels have all lifted so significantly. I mean, but having said that, both approaches are valid, right? You can either map it yourself and then go through a Schedule 1 process to update your mapping. And that's perfectly okay, I would think. It's like, particularly if it's dovetailing with, if it's led by the regional council and they go through their Schedule 1 process to update their maps, you could quickly follow the Schedule 1 process to adopt it, couldn't you?
I think, Mr. Chair, we've seen examples too in the city have done that. And I think there was a feeling that non-statutory layers excluded participation from those potentially affected. So they felt while they were able to update them, they were potentially excluded from actually having a say. In a statutory sense, the rules will apply. Council can change these provisions in the background. And I perhaps think that Auckland City may be an outlier.
There are some significant implications from the updated mapping, because what you would call a 1 in 250 year flood has effectively become the new 1 in 100. That's massive. And it has also implications for central government, because they're the ones upping up money to compulsorily purchase the unlivable properties. So it's not an easy problem to solve.
Yeah, just to comment, like the RPS doesn't allow us discretion to not include these in the district plan.
Yes.
So you must include.
Yeah. So it's RPS led, right?
Yeah.
So any change will come from the RPS first. They would probably follow a process whereby, I mean, they could hold joint hearings too. You could actually run both changes at the same time. Or you could just they could lead the process and have most of the hearings, and you could follow it. You have the option to follow an adoption process afterwards. If the hearings were mostly held at the region.
Yeah, I mean, I would imagine you could undertake a pretty streamlined process, because you're giving effect to those maps when they're updated. The ability to challenge that is pretty much.
Same hearings again.
Yeah, yeah.
Particularly as you have to follow the regional council's lead. Okay.
Just one more comment there. At page 5 of the Tonkin and Taylor assessment, where it discusses the different geomorphological units that are used to assess coastal erosion hazard risk. So I'm not across the technical details of that, but I'm pretty sure from that they do assess geomorphology as part of assessing coastal erosion risk.
Yes.
So the second question that I had was around the introduction of the flood hazards into the plan, because that's a significant change. And the public have questioned why we need to go through a resource consent process, a land use consent process, when we're already going through the same process or similar process, basically with the building consent aspect. So addressing the hazard in section 72 or 73 of the Building Act, compared to getting an additional consent through the Resource Management Act, through the district plan. It's understandable through subdivision, but a land use consent, essentially replicating similar processes of mitigating hazard for any building. Is there a response around that?
Yeah. So my understanding, the Building Act just focuses on the risk of that particular building. It doesn't consider wider impacts of how it might affect downstream properties or the sensitivity of that activity to the natural hazard. So it's a much narrower consideration of natural hazard risk than what you get under the RMA resource consent process. So I think there's quite well established reasons why managing natural hazards under the RMA, including those factors. One, that you can discourage particular activities from establishing them in the first place. You can consider wider effects of that activity locating there on downstream properties, and also the sensitivity of that activity to that risk, which the Building Act will not consider those factors.
I think, Mr. Chair, too, there's we've got statutory direction to undertake that as a no, and I think that one of the fundamental differences that we have from the RPS, for example, is a risk-based assessment, right? So probability times impact, and particularly around things like flood, I think historic practice has been identifying the extent with little detail on potential risk that flood extent might pose or activities within. So there might be, for example, ponding there up to 30 mil or 300 millimeters that might be lower risk that may be able to be adequately mitigated. Similarly, there could be 1.8 metre flowing at 2 metres per second. And that's part of the regional council modelling that's done. And that's perhaps a no rather than a mitigate kind of option. So there's some refinement in the approach to managing natural hazards that will be coming through in this framework.
And I suppose that reflects your different functions, isn't it? Because the regional council will be concerned with avoiding mitigating the flooding, whereas you're saying the council also needs to consider the risk to people and communities. Like you're using the same maps to do those two functions. But you haven't said that those are the factual basis upon
There's also,
which both functions are exercised, right?
yeah, obviously the RP sets out statutory direction for us in terms of managing those hazards for our purposes as well. So,
Okay, so that's quite helpful, isn't it?
I had one last question about flood mitigation works from the Northern Regional Council and the timing of that. In Kaikohe, we've had the whole catchment of flood mitigation. And that's just coming online now with the completion of Quarry Road Bridge. And that will, I would anticipate, affect the flood hazard maps as a result of the changing of those flood mitigation works. At what time would the maps change? Would it be the completion of the works? Because in Kaikohe, for example, they're only just been completed now, and yet we already have the maps that we're bringing online, and so that would significantly change that whole catchment.
yes, I mean, we looked at, there was one that we specifically, one catchment we specifically looked at, and the understanding is that there is a long program of works associated with one particular site, or one site in particular, and that we didn't have the available mapping from regional council to be able to amend anything at this stage. But similarly, there are works still continuing, and there would need to be a further update as well. So until the works, I think the capital works were programmed for another 2 years to continue. So there was still additional work to happen. So again, you go back to some of the first questions about, you know, when and how we update, and, you know, once we have the information modelled and mapped, we can, and funded, we can go through the plan change process.
It might be a couple of years away to update that series.
Yeah, just a couple of questions of clarification for me. Thank you. I had a lot of questions about the mapping, but that discussion has been really useful for me. Just to clarify, there are a lot of submissions requesting mapping changes. Taylor have done their expert review of that. No one is disputing that, so there's no decisions we have to make on mapping related issues. Is that your understanding?
There hasn't been any evidence provided in response to Tonkin and Taylor's review.
So that's the definitive voice at this point in time, expert voice on matter.
My understanding.
Thank you. And then the second question I had is this coastal environment chapter. Just so that I'm really clear on what your appendix markup for that is. Which is your 1.2. 1.2.
Yeah.
Is the strike throughs and underlines in this appendix 1.2? What's different from what was at hearing 4?
So that,
Is it only those two rules that you mentioned?
I mean, part of this relates to some of the challenges we face with the national planning standards in terms of what they say about where rules should be located. So they're quite clear that coastal rules needs to be in the coastal chapter.
Yeah.
From my perspective, it would make more sense to have the coastal hazard rules in the natural hazards chapter. But so that's creating some complexities around the coastal hazard rules. So what you're seeing there is just based on the notified rules. So there will be some numbering type issues as a result of hearing 4. This doesn't take into account any of the recommended changes to the coastal environment rules hearing four.
Oh, it doesn't.
No, that's, so they like.
Because I
essentially-
sort of had a quick look at it and I thought I'll just do that later.
Yeah, essentially from what was considered at hearing four was coastal hazard rules, R1 to R9, and then the coastal hazard rules flowed on from that. So they were, we allocated them to this topic because we thought it would make much more sense to address them here, but structurally in the PDP, they sit with the coastal environment. Just
That's helpful.
Okay, so
Thank you.
the coastal, the latest version of the coastal chapter, which came in your right of reply.
Yeah.
Is silent on submissions on coastal hazards. And deliberately so.
Yeah.
Okay, so.
So this little additional what we heard.
Yeah.
Yeah,
So
okay, that's.
These need to be married into the right of reply version of the chapter 4 provisions.
Yes, well, we can certainly show how that would look. Like we won't necessarily need to show you all the whole coastal chapter again, but we'll say these will slot in under here. If you look at the PDP, it's notified now, it's got the coastal environment rules. And then it says, and then there's a subsection for coastal hazard rules. So it's like that clear distinction.
I'm thinking about how we progressively update our plan with all the recommended changes, ours and councils. And yeah, I mean, so this could actually stand alone as its own sub-chapter.
Yeah.
Or it could be just introduced. I'm not asking anyone to open up that document right now, but as the right of reply for the coastal provisions in hearing 4, that just has the coastal provisions in it, or it doesn't?
Doesn't have the coastal.
It doesn't have them in it, okay. So this could be this could be a sub-chapter.
I mean, if it's helpful, it would not be hard at all for me to insert those coastal hazard rules to the right of reply
Yeah.
to the hearing board, just to say.
Back to you on that, I think we'll, this is just a logistics thing that we'll coordinate through the hearing and you to Mr. Withall as to whether we have it sort of sitting as a recommendation as part of this hearing and recommended report, or whether we try and marry this back into hearing 4 and call hearing also part hearing 13. Which we knew was an inevitability at some point. Okay, look, I'll think about those logistics, and now I understand it better. These the first time you looked at the particular coastal chapter. That's really clarifying. Thanks. Okay, just what we've got lots of time. I think we might be ready for our first submitter. I can see two witnesses from telecommunications submitters sitting online. So if you pitch them in. Good morning. Can you see and hear us?
Morena,
So we have Mr. McCarrison. Good morning. You were here as a corporate representative of the telecommunications submitters.
yes, that's correct.
Good morning. And Mr. Anderson, you were standing in for Mr. Horn, who can't be here.
That's correct, yes.
I'm going to be heading the planning part of it.
That's right, yes.
Yeah.
Okay, well, welcome both. I will hand it over to you.
Thank you. So just to provide a brief summary of Mr. Horn's evidence, the reason that the telecommunications companies are seeking kind of exclusion from some of the district plan provisions regarding natural hazards is to align as best as possible with current and proposed national direction. I outlined in my brief Regulation 57, which excludes regulated activities under the natural environmental standards for telecommunications from having to comply with natural hazard provisions in district plans, and that is limited currently to any new poles in urban areas. The recently released national direction, which came in after Mr. Horn and I submitted our evidence, has a twofold change to those provisions. Firstly, the National Environmental Standard for Telecommunications Facility is proposed to apply more broadly, with the only non-regulated activity being new poles in residential zones as opposed to wider urban zones. There's no changes proposed to Regulation 57 of the NES. And secondly, as touched on by Mr. Waith, the proposed National Policy Statement for Natural Hazards specifically does not apply to infrastructure as defined in the RMA. And the reason given in that discussion document is due to the lineal nature of some infrastructure and the functional and operational needs of other infrastructure. And that was outlined in Mr. Horn's evidence. A slight overview that I can provide in terms of my experience with planning for telecommunications and natural hazard areas is that mapping of natural hazards is welcomed. Regardless of whether or not it's regulated, in my experience, the telecommunications companies always look to avoid being located in a natural hazard area in the first instance and design accordingly if avoidance is not possible. So an example of that, recently we had a site in the Hutt Valley in Wellington where it was within a 1 in 100 year flood level. It was a completely regulated activity under the NES as it was in road reserve, and the design response was to build a mound up so that the equipment in the cabinets was above the 1 in 100 year flood level. That's my brief overview. I agree with the regulations or the amendments to the regulations as outlined in Mr. Horn's evidence, and I'll pass over to any additions from Mr. McCarrison.
Okay, thank you.
Yeah, I really don't have a lot more to say other than happy to take questions, but for the industry, it's the flood mapping information being as real time as possible, so as recent as possible, because that enables our geotech and flood hazard engineers to design network accordingly. And there was a couple of photos of examples of that in the corporate evidence primarily. So as Tom set out, we seek to avoid, but if development is in a floodplain or we have to cross through a floodplain, then that's where we will need to put networks. The NES is designed to ensure that we can put our equipment above a floodplain, so raise the space underneath the cabinet to be above that without, when it's on the road, without being infringing any district plan rules and so forth. And poles, naturally, you'd have to go pretty high up in terms of floodwater before they're damaged. And there's just no history of our networks being damaged by flooding in terms of taken out by paths. Occasionally, we will have wet cabinets, and so we'll put in temporary facilities to manage that. So that's kind of where it sits. The amendments to the NESTF, the industry, we're actually doing a workshop with MB and MFE on Thursday to discuss some of the issues, and clearly the industry would prefer to have regulated activities in residential areas as well, particularly to support future urban spaces, basically. So happy to take any questions on that.
Yes, I was thinking about what the risk was to telecommunications, and I can understand how poles can be quite resilient, and even underground cabling can be quite resilient. And then I was thinking cabinets. And so is it your view that it's the telecommunication operators who want to take that risk?
Sorry, I think the microphone link might have just broken because I could see your mouth moving, but no words coming out. Are you getting that as well, Graham?
Yes.
Can you hear me now? I don't know.
Yes.
Yes, that's better. Thank you.
Okay. I don't know what I'm doing differently.
Yeah.
I'll just maybe stop moving. Yeah, so it seems to me that the risk element about damage, it would be the cabinets as opposed to underground lines and power poles, which, you know, by their nature, quite resilient. Is it your view that the telecommunication operators want to take that risk as to whether to place a cabinet potentially in a flood hazard area or potentially fire hazard area too, for that matter?
They would only take that risk if there was no alternative site available. Yeah, as that's my experience.
Do you get many of those facilities out of urban areas, or are they mainly in the cabinets?
They're everywhere. Everywhere there's a requirement for a telecommunication pole, mast, cell site, there's a requirement for cabinets. They go hand in hand. The NES regulates the pole and the cabinets, but it regulates cabinets everywhere. So in terms of that regulation 57, all cabinets are excluded from the district plan provisions.
Yeah.
Okay. And just help me. I mean, there are so many national policy statements and environmental standards being changed at the moment. I'm really struggling to catch up. So the telecommunications NES, I think that was enacted in 17. Is that that's still the 2017 version?
Currently, but there's a 2025 version being consulted on as part of the latest package.
Is that at an exposure draft level?
That's sort of tabulated.
Partly.
Yeah. These are the provisions that we're wanting to change, and where the government has options, it said which its preferred option is. So it's going to keep the same base document from what we've seen so far, but with amendments to certain provisions.
Okay, but it hasn't progressed to like MFE exposure draft.
No.
Not at this point.
It's just I just want to know where that's at. So that's probably going to come down the pipe during the life of this hearing process.
I'd imagine so. Graham, you've probably got some more detail on the timing.
So the government's indicated that it will come into effect at the end of this year. There was debate around whether it would be February, March next year, but Minister Bishop has tried to make it clear the end of 25. And we're not going to get to see an exposure draft. So they're taking public submissions and then going straight into drafting and then through to cabinet approval. So
Obviously, agency.
yes, across all of the national direction changes, which as has been set out includes the natural hazards one, which is an indication that infrastructure would be exempt, but
So natural hazards is the national policy statement,
yes,
and that has just been released, or what is that? Is that a gazetted version?
No, it's the same, exactly the
Same
same as the
version.
NES.
So that's an exposure draft, is it?
It's this is a discussion document, and now I've kind of
Yes.
got not exposure draft per se, but it is quite specific in terms of the provision.
And is that going to have the same urgency about it? I would suspect.
They're all progressing.
they all are.
All three of those four of those packages.
No, that's good. That's what I think we. Okay,
Yeah.
so we know that they're literally coming down the line.
Yep.
It might. We have a hearing right at the very end of the process where we wash things up and miscellaneous and pull all these little loose threads together. It might be nice to see you again and see if you could help us update where those things are at.
Yeah, certainly happy to help with that.
Yep. Yeah, more than happy.
Okay. Have you got any questions, Mr. Keith?
Yeah. Thank you, Mr. Anderson and Mr. McCarrison. My only question is the suggested wording changes in Mr. Horn's evidence at paragraph 22. Are they still your evidence to us that that's what you'd like to see changed? There's nothing new that's come out of these EPS changes that need changing?
No, I'm just double checking it now, and it's that wording works with in terms of what's proposed in the NES and NPS NH changes or proposed
So it's
changes.
NHR3, NHR9, and then coastal environment R12.
12 and 16.
Okay, so they're the only changes that you're seeking to be
Yes.
made. Okay,
Yes.
thank you.
Council officers, do you have any questions or clarification while we've got these witnesses here? That's why. Do you have any questions or clarification while we have these witnesses here? No. Okay, well, thank you very much for your presentation and your attendance.
Thank
And
you.
we might see you again. We might see you again
Yes.
soon.
Excellent.
Exactly.
Thank you
Yep.
for your time.
Cheers. Thank you.
Top Energy. And it's Taryn Collins as well.
She may or may not be attending.
Okay. Okay, hello, Mr. Badham.
Morning, sir. Good morning, all.
And it has it on our schedule that you may have Ms. Collins with you, Taryn Collins with you.
Yes,
No?
I did forward it on to her, but I'm not sure. I think we're slightly ahead of schedule, so she may or may not attend. And that's fine. I don't. To be honest, I think this scope of evidence that I'm presenting today is quite narrow. There are only two minor points that I present on, so I'm comfortable to continue. And if Ms. Collins joins in, that's fine. Or if there's anything outstanding, I can take it to her at a later date.
We certainly don't want to rob Ms. Collins of her appearance. We have another submitter that's here that may present their evidence. Now, if you'd rather take a back seat and let another submitter go first, Harbour Neutral New Zealand Trust, would you be happy to present now so that would you, I mean, so look, I'll place the decision in your hands. You've got the option of proceeding on your own now, or we could let the Harbour Neutral New Zealand Trust present their evidence. And then you can follow on from there. We've got plenty of time, so.
Look, sir, I'm happy to present. I'm happy to present now. Miss Collins was only a maybe attendance anyway, so I'm happy to push through now.
Okay, well then we'll hand it over to you then.
Okay, thank you, sir. So yeah, good morning all. I think I know I have been in front of the hearings panel a number of times now, but I am representing Top Energy in these proceedings and have been for the entirety of the Far North Plan Review. So I have pre-circulated a brief of evidence, which I understand you will have a copy of and have seen and read. So usually for these hearings, I have been presenting a PowerPoint presentation, but in this case, I've only got two very narrow points that I address in my evidence. So I'm just going to propose to briefly talk through those 2 points, and then I'm happy to take any questions or clarifications from the panel following that. So, yeah, I think as outlined in my planning evidence, there's a large, I guess, degree of support from the recommendations of the reporting officers from the various chapters. And what was left was a specific submission point relating to an objective in the natural hazards chapter for infrastructure. So that's outlined in section 4, paragraph 4.1 to 4.4 of my evidence. And essentially the point I made from a planning perspective is you've got policies in the natural hazards chapter, which in my view are not hanging off an objective. Now I know that this issue has been raised right throughout various topics in the proposed district plan review as it relates to the infrastructure chapter, with the direction and general approach being if it's relating to infrastructure, it's in the infrastructure chapter. But as I've picked up with a number of other chapters in the plan, sometimes it's not necessarily the case that it's quite explicit and specific relating to infrastructure and the topic in hand, in this case, natural hazards. So my suggestion is that as a result of my evidence, that an objective is included explicitly in the natural hazards chapter, which basically states the operation, maintenance, repair and upgrade of existing infrastructure within areas subject to identified natural hazards is enabled to ensure a resilient and reliable network. I did pick up the end of that conversation you were having with Mr. McCarrison and the new national direction. So it's good that that's on the panel's radar. It is relevant. There is a lot of change coming, not just in the natural hazard space, but in the infrastructure space, which is signalled. And I haven't addressed that in my evidence because, again, the dates and timings, etc., of circulation, but it is, I think, something that will be relevant for the panel as that moves forward. So I thought I'd just note that here. Ultimately, you do have to apply and interpret the law and the national direction that applies at the time, but you do, there is change on the horizon, is what I'm highlighting there. So that's the first point I address in my evidence. The second one is quite specific and quite narrow, and it relates to NH Standard 1. And just in that statement, there is in that note, there's a requirement that any application for resource consent must be accompanied by a report prepared by a suitably qualified and experienced engineer that addresses the matters identified in the relevant, and the wording proposed was objectives, policies, performance standards, and matters of control and discretion. So there was a couple of points that I did highlight with that note. I think that need to be fixed. In particular, I think just around the references to an area of the site. What I'm getting at there is you're going to have large sites, pieces of land, which might only have an isolated natural hazard area within it. So an area of flooding, say in the northeastern corner of the site, but then the rest of the site might be free of natural hazards. Just targeting that assessment so it's specific to the area of the site that is located within the mapped river flood hazard. That's the first change I've highlighted there, so that the assessment is targeted to that and you're not caught up in having to give an assessment of the entire site if it's not subject to the river flood hazard area. And then the second, I guess, change was there was a reference to relevant objectives and policies. Now, in my view, an assessment from an engineer, so this is a assessment which has been required by a suitably qualified and experienced engineer, I don't think it's appropriate or necessary for them to be addressing objectives and policies. In my mind, that's a planning assessment that would be picked up in a planning application, and you want that assessment to be targeted towards the performance standards and the relevant matters of discretion in the applicable rule. So that's a very quick synopsis of the two changes that I've outlined and recommended in my evidence in chief. I think I'll leave it there, and I'm happy to take any questions or clarifications or comments from the panel on that basis.
Okay, thank you. Look, I just really want to understand your first point about the new objective. And perhaps you just want to take me through your rationale as to why you think it needs its own specific objective, and in particular, why policy 10 doesn't work adequately in your view. And
Look,
if we put your objective in, which reads a lot like policy 10, then where does that leave policy 10?
So in my mind, sir, a policy is there to give effect to an objective, to say, well, two ways to say how you're going to achieve an objective, and that can be done via a rule or provision in the plan, or it can be an assessment type policy. So telling you how to assess something that comes up against, applies for resource consent, has to be considered against those things. So what I was simply highlighting there is that it looks like you have an objective, you have a policy 10, which is hanging without an objective. And in my mind, it makes sense to have an objective there, which you're trying to achieve relevant infrastructure, that policy is given effect to. I don't disagree with what you're saying in terms of the alignment of the wording. It's really that point I'm making, is you sort of have a policy hanging there, which is not necessarily directly relevant to an objective in my mind.
Is it your evidence that policy 10 should actually be an objective?
Well, in a sense, that could be the case. I don't have a problem with policy 10 remaining, but I do think at the moment it doesn't hang off an objective. So whether that became the relief or the objective that I've suggested becomes an objective, or policy 10 becomes an objective, that could help address it. But then of course you don't then have the policy underneath it.
Yeah, I mean, policy 10 is specifically worded towards infrastructure. And I suppose I'm going to play devil's advocate here. Objective 3 relates to infrastructure. So when you say it doesn't hang off an objective, there is an objective that is, well, and policy objectives 1 and 3 do reference infrastructure, don't they?
I'm just going to bring up the actual wording in front of me, sir. So I've got it to hand.
Doesn't hang off an objective. Perhaps your objection is that it maybe isn't linked better to, or
Yeah, I think it's more effective and more specific what you're trying to achieve with those components. So objective, I've got the provisions up in front of me here, the notified plan. So you referenced objective 1, is that correct, sir?
Yeah.
Yes, that's the district has safe, efficient and resilient infrastructure that services the current needs of people and communities in the district. And then the other one was objective 3, infrastructure is protected from incompatible. So in my mind, objective 3 specifically is more relating to reverse sensitivity. So that I think that's slightly different in terms of how it relates to the policy 10. And then objective 1 is more broadly about the resilient, safe, efficient and resilient infrastructure, whereas the policy is quite targeted towards existing infrastructure.
Yeah, I mean, okay. It's almost as if you're arguing to have policy 10.
Sorry, sir, I just realised I've been reading the wrong objectives there. My apologies, I brought up the wrong chapter. I'm going to correct that for the record. Had the wrong chapter up.
Yeah, but it seems to me that I think the upshot of what the public's saying is that policy 10 might need to be considered to be an objective. And I'm not saying this is my opinion, this is what I'm just trying to understand.
Yeah, I accept that. Yeah.
And then maybe objective 3 might end up becoming a policy.
Possibly objective. Now that I have the correct objectives in front of me, objective 3 does have a policy type look to it. Yes. So I think you could skin that cat in two ways.
So I was just trying to think. I was trying to get my head around where I think you were going. I think this sort of is where I think you are going with it. We've got everybody in the room, and I'm happy to let you respond and have a discussion going here, or you can keep your powder dry and leave it to your right of reply. I really don't mind, but the opportunity is here for you to give us some comment and add to the discussion now if you wish.
Yeah, I think the issue is there's some quite specific stuff there around new infrastructure in hazard areas, and that's generally supported. So I'd be a bit worried about moving away from objective 03. What Mr. Adams highlighting is that there's no objective relating to existing infrastructure. My view is that there's quite a lot of just repeating policy 10 and objective as an objective doesn't really add a lot of value. And there are wider sort of objectives in the infrastructure chapter that policy 10 can kind of give effect to.
I was going to go there. I mean, you reported on the infrastructure chapter.
Correct.
Did you make any? I didn't do the infrastructure hearing, so I'm a little bit amiss. But is there a general objective of existing infrastructure? I'll be surprised if there isn't. Those. Did you change those objectives? Could you? So we could have a look at those now. Do I take your evidence as saying, look, providing for existing infrastructure? It's covered by the infrastructure objective.
I guess so that the objective 1, which was in the infrastructure chapter, I'm thinking about, around having safe, efficient and resilient infrastructure. Resilient in my means resilient to natural hazards. So it's a broad objective. It's not specific to existing or new, but in my mind, it captures both. And in my response to the need for a specific objective for existing infrastructure and natural hazards chapter, my view was that those broader objectives in the infrastructure chapter already do it. As I said, there's limited value, I think, in repeating policy 10 as a specific objective in the natural hazards chapter.
Yeah, I'm just calling up. Those. Right, so I01 is possibly the one that you
Correct.
would identify actually.
As it relates specifically to resilient
Okay.
infrastructure.
Well, Mr. Bowden, you heard all that. Do you
Yes.
want to response?
Yes, happy to provide a response to that. So I do address that in my evidence. So if you look at paragraph 4.3a, so policy, what I've said is policy NHP10 provides for the operation, maintenance and upgrading of existing infrastructure and identified natural hazard areas. As notified, this policy does not presently, so as I've said, implement an objective. I01, the objective, and this is the one that I miscorrectly quoted earlier, that objective doesn't specifically, so I take what, I take the point that it mentions resilience, but it's not specific to natural hazards. So you're making that jump to say, well, resilience then is specific to natural hazards. What I'm saying is in the natural hazards chapter, as it relates to existing infrastructure and the policy, is it needs to be more specific. I don't think I cannot draw a direct link to objective 1 and policy NHP10 achieving that. I think it is clearer and more efficient that there is Mr. Wyeth has said, limited value. I see there is some value. I don't see there is any downside to being more explicit in the objective, provide an objective for that in the natural hazard chapter, rather than trying to rely on non-specific wording in the infrastructure chapter. Is essentially the crux of what I'm saying in my evidence there.
So, I mean, resilient really would include natural hazards, wouldn't it? I mean, resilience is used in a number of national instruments in the context of natural hazards. NPSUD is one that jumps to mind, and I probably could do a Google search and find. I mean, my understanding of resilient is that it is able to respond to external forces. Being one of those obvious ones would be natural hazards. I don't think that's a big stretch, do you? Or do you?
No, I don't disagree that resilience is a common term in natural hazards planning, not at all. But what I'm saying is my preference and my recommendation is to be more explicit in the natural hazards chapter at the moment. So you're not required to make. I think this is a common theme that I've sort of made across the different chapters and titles, is if you're having to make a leap from here to another chapter, if you got the ability and it's not going to cause any downside, having a specific objective in here is clearer for plan users as well. But I don't disagree with what you and Mr. Wyeth are saying in terms of resilience as a common term used for natural hazards.
Okay, great. No, thank you for that answer. I think I understand where you're coming from on that. I'll see if the other commissioners have any questions.
Yeah. Thank you, Mr. Badham. I've just got one question about your proposed wording changes to the standard, which is all about information requirements. Your proposed changes specifically include the words mapped river flood hazard area, whereas the way I read the standard, it's all natural hazards, land instability and fire risk and all that sort of thing. Is that a problem with the way you've worded it there? Does it need to be as specific as you've said or not?
So the point, I'll take you, if you've got my evidence in front of you, I'll take you to 4.10. So where have I explained and justified that change? So I've said, consider recommend wording more. So point A refers to all areas potentially affected by natural hazards, whereas the rules, so there's specific rules that refer to that standard. And so the point I made there was that the specific rule was S16 only relate to river flood hazard areas. And actually, so yeah, and then I've got off there a footnote which refers to the specific rules, so NHR7, NHR8, and NHR9. So my point there was those rules, as I had interpreted and followed them, that they were specific to the river flood hazard. Therefore, if those are the rules that are referring to the standard, that should be the mapped natural hazard that's subject to the standard in the note in the assessment.
Just going to bring up NHS16. I think Where do I find NHS 16?
If it's helpful, I can also probably share a copy of the provisions on the screen. That would be helpful.
This one. I'm just referring to your paragraph 14A, where you refer to
Sorry, Zephyr, in my opinion, hang on a sec. I'm just going to look at the.
Oh, so, that's a 1.
Sorry, that's a 1. I don't know why I've got a 6 on there. That might be a typo. But that's why I say it's therefore logical, in my opinion, that NHS1 should only refer to an area of the site that is located within a mapped river flood hazard area. So the footnote, if you look at the on my evidence, I've got a footnote after flood hazard areas to 7, and it then refers to the rules where the standard is referenced, or based on what I had reviewed.
Yeah, that's clear.
Yeah, so that's why I have recommended that, because as I'd understood that standard, it only applied to those rules, which only applied to the river flood hazard area, which is mapped, which is why I used that terminology.
Okay, that's clear. Thank you for that clarification. Maybe we'll get this after.
Yeah, so we just clarify that it doesn't relate to all natural hazards. Is it just relating to flooding? Is that correct?
Well, there's 2 issues here. Yes, in the natural hazard rules, S1 is referred to in rules that specifically relate to river flood hazard areas. So if the balance correct in that respect, and the same applies in the coastal rules that refer to coastal standard 4, I think it is. And so they're specific to coastal hazards and mapped areas. But there's a broader sort of statement in advice note 2, which is around relation to all natural hazards. When the rules are triggered, that you must engage a suitably qualified expert to make an assessment. So that sort of requirement will apply to broader hazards around land instability, wildfire.
Yes.
And also in the subdivision chapter, there's a note that's quite specific, that when you're assessing subdivision in an area of land susceptible to land instability, that you must include a specific assessment. So it's sort of, you can look at it 2 ways. Like those S1 requirements could be more specific to the hazard they refer to, provided that you also have that broader requirement to engage an expert when those hazards are relevant.
What would trigger those other, that would be the other activity status in the other rules in the plan?
It would be once the resource consent is required.
Yes, correct. Okay. So you wouldn't be deliberately limiting the scope of assessing other natural hazards if you were to make this standard specific to.
No, those rules are specific to that river flood area or that coastal.
So that's something for you to consider.
Yeah.
Yes, thank you.
No.
Okay, good. Very helpful discussion. Thanks, Mr. Pym, as always. We've got no more questions for you.
Okay, thank you very much for having me. I'm happy to enjoy the rest of the day.
Thank you.
Cheers.
Yes, and Colin has just confirmed he's at a conference in Christchurch, so won't be appearing today, but obviously Joanne is online.
Oh, we do have.
Good morning, everyone.
Good morning.
Can you hear me?
Yes, we can hear you loud and clear. Can you see and hear us?
Yes, I can, which is good. You've got Colin's apologies. He's down in a meeting for the rest of the week, which he was really excited about attending, as you can probably guess, with all week meetings.
We know he would rather be here, but we will accept this apology.
I will convey that to him. So can I take that you have read the evidence produced by my colleague Jessie Brennan?
Yes.
I would like to take this opportunity once again to thank the council for the thorough job it has done with its Section 42A reports and the recommendations from its staff. It has definitely made this whole proposed district plan hearings process a lot easier for federated farmers and especially myself. We only have one thing I would like to talk about from the evidence, and that's in respect of rules HSR 6, R7 and R9. We, in our submission, sought that the classification in these rules should be a discretionary activity classification rather than a non-complying activity status. We felt that this would allow the council to set appropriate matters of discretion for controlling significant hazardous substances facilities within a significant natural area and flood or coastal hazards area. Council staff has recommended rejecting our submission on those rules, stating that there's not enough evidence to analyse why these activities should be treated differently and how agrochemicals, fertilisers, acids or paints would be considered to be a significant hazardous facility in the PDP. While there is no clear definition for a milk processing facility provided in relevant planning documents or the PDP, Federated Farmers understands this to mean a plant that takes raw milk and processes it into various dairy products. We also interpret the definition of significant hazardous facility in terms of the storage of hazardous substances to only apply when it is associated with manufacturing. Federated Farmers largely accepts the reasoning provided by council staff. However, we would like to seek confirmation from the council that those rules are not intended to capture farms that carry out activities such as a dairy farm producing milk and storing this on a short-term basis for collection, or the storage of hazardous substances, including agrochemicals, fertilizers, acids, etc., as a significant hazardous facility. Any questions?
Yes, so I think with regards to milk, so you're saying, you want confirmation that the container, the vat, that you store the recently milked milk
Yes.
and stays until it gets picked up by the tanker, whether
Yes.
that becomes a significant hazardous facility or not.
Yes, because it's storing a raw substance.
Yes, as opposed to a milk processing facility, which I would assume is just a dairy factory.
That's how I would interpret that phrase.
Plants, yeah, milk processing plants. I'm assuming that's a dairy factory, right?
Yes.
Yeah. Okay. This is one of these opportunities where I think we can let the council officers. You've looked at the evidence. You've had a little bit of time to think about it. Do you want to give us a response to the question?
It's not our intention that dairy farms would be included in
Just dairy
this
factories.
facility.
Yeah.
It was solely the intention in M that would be a dairy factory.
Right. Does this prompt a potential tweak to a definition at all?
I think it definitely was not our intention.
Yes.
James and I spoke about this yesterday, and we will think about it further.
Yeah,
as to whether it needs to be tweaked or whether it's in itself self-explanatory. But we will think about whether it needs to be tweaked.
Yes.
Because we see milk processing plants as being dairy factories, but whether it needs a slight tweak is something we will talk about further.
Yeah, and
Because it was never our
give
intention.
you the opportunity to think of that.
Yes, absolutely.
It might help the submitter to hear that. Did you hear that exchange?
Heard that exchange and support the position that council staff are taking to consider it further.
So I think you've had the clarification that it wasn't intended to capture anything that you do on a dairy farm, unless your dairy factory is part of the farm. It's meant to capture the milk processing plants, and so the council officers, as you know, they get the right of reply in a couple of weeks' time. This gives them the opportunity to think through the implications of what's been delivered and come up with some further solutions. So we'll have some you'll have some further reporting on that in that right of reply. As you know, that'll go up on the council's website. And we won't start doing our interim deliberations until we receive that report ourselves. So
Excellent.
yeah, so I think it's an interim solution for you.
It's a good interim solution, and we look forward to seeing the right of reply in a couple of weeks.
But let's just see if we've got any other questions for you from the other commissioners.
I just had a question about the footprint of 250 square metres. And the reporting officers have a recommendation for 100 square metres. But Federated Farmers put forward increasing the footprint to 250 square metres.
Yes.
Based on what Federated Farmers considered to be the size of a building that you might use on a farm.
Yes.
I think, so my question is, why 250 square metres and compared to the reporting officer's recommendation of 100 square metres for an ancillary building such as hay barns, etc.? Can you explain operationally about those, you know,
What our members have told us is that a building of 250 square metres is of sufficient size to store enough hay bales or enough equipment. So it can be stored in one place in one part of the farm. They feel that a smaller building of around 100 square metres, you would end up having potentially more buildings because you can't store as much in that building, and their preference, because it helps them operate more effectively, is to have that 250 square metres. So you've got one building for storage, and it can address all the operations in that particular part of the farm where it's located.
So the other question I had, because the officer's recommendations, it's around that similar issue. It talks about the reporting officer said there should be an incentive on a large farm to keep away from river hazards. I guess the point that you've pointed out is what happens if there's no other area on the site. If it's an arable farm, so good soils are usually in a floodplain,
Yep.
the best soils. So do you have any more narrative around that, just to understand that as well from your members?
Yeah, while appreciating council staff's position, our members typically will locate buildings away from flood hazards where they can. What they're asking for is the ability to have an auxiliary building of sufficient size to do the job that's needed in a floodplain, if that happens to be the only alternative. They don't typically locate in floodplains because they have to, because they want to. It's usually because they have to, and then they would adapt the building to take into account the fact it's in a floodplain, like having it raised more off the ground, or storing different things in that building. So I think a lot of it is just to allow flexibility for operations, and realizing that sometimes there is no alternative to locating in a floodplain. Yeah, our members are just being very practical at the moment. So this is an issue that we discuss a lot among various councils about the sizing of auxiliary buildings, particularly for farming.
Just around that definition of ancillary buildings, you talked about the word or the use for a hay barn. There are other types of structures that aren't a built structure, like shelters between containers and other type of more temporary buildings that can be used for shelter. In other councils you've seen, have you seen any changes to definitions to allow for those more temporary structures? Relocated if needed?
Normally, temporary structures are dealt with on their own as temporary structures. That's about the only thing I can say is I've never had, well, to date, I've never experienced a temporary structure being included as an auxiliary building. It's always been a temporary structure because normally that structure is limited to a number of days or will have other matters of consideration for the council and for the person putting it up. So an auxiliary building implies that it can be permanent, where a temporary structure is just that, it's just temporary and normally has a time period associated with it.
Okay, thanks. Look, I've just got one question, and this relates to your last paragraph, where it looked like you might have conceded. But I'm just wondering now whether you want that still to be a live consideration. You provided some further information, so it could give the council officers something further to consider.
It was basically just to give additional information for consideration. We cannot find fault with what the council officer has said, and we actually agree with that. We just know that in reality, sometimes an auxiliary building has to be located in a floodplain, and our members are telling us that 100 square metres is not big enough if it's going to be a useful auxiliary building for them on a farm.
It seems to me that really it's coming down to what the trigger should be, and there's an arbitrariness about it, but it might be arbitrary, but it's certain. And trade arbitrariness for certainty, and certainly that happens in district plans all the time.
Yes.
I can get my head around. I've been on a lot of farms, but I haven't done any farming. How big would a hay barn normally sort of be? I mean, I know they come in all shapes and sizes, but would you get 100 square meter? Would 100 square meter hay barn be a normal size, or just a small size? Or hay barns are usually 200 or 300 meters.
Okay. I'm not a farmer. I've never been a working farmer. My perspective would be that 100 square metres would be small compared to the hay barns I've seen on members' farms.
We need them. Yeah.
But I haven't gone out to measure how big the hay barns are. I mean, if the panel would like me to do that, I can get hold of a couple of members and see if they can give me sizes for their hay barns.
Yeah, I mean, I looked at 100 square metres. I think, yeah, it's a reasonably good sized building. But I suppose we probably need Colin here to help with that question.
Yep, and I can get hold of him in probably Thursday, Friday.
Well, it all comes down to whether you want this to still be a live question, or whether you're going to stick with the wording in your final paragraph.
No, my work colleague did a fantastic job with his evidence, so I'm going to stick with what she has said.
Okay, right. Okay, well, a useful discussion anyway. Further questions coming out of this? Any clarification questions coming out of the council while we've got Federated Farmers here?
No, not really much to add other than what's been provided. I guess just reiterating that's a threshold as a PA permitted activity. So it's not saying you can't have a 250 metre building in a hazard area, but you probably want to assess that quite carefully to make sure it's appropriate and that you have looked at alternatives.
Yeah.
And I was just talking to Ms. Woodster, it was understanding the 100 metre threshold was based off the unitary plan, and there's also the Building Act thresholds around 110 metres. Well, which is probably something we could look at a bit further.
Yeah, I was going to say, look, we can let you know that we've gone down that path as the hearing for,
Yeah.
we thought the Building Act threshold sort of provided a far more practical. So we thought, the difference between 100 and 110 and the practicality of using the Building Act. So it would think that perhaps should follow here.
Okay,
We can let you know that that's where we're leaning.
The Building Act refers to A sheds and whole sheds reflective of common fund.
So I think you've got scope to recommend 110 to us.
Yeah, we can consider that, and I'll consider that, I'll reply.
Okay, so look, we might have found you another 10 square meters.
we would appreciate that.
Okay. Okay, well, thank you very much, and give our regards to Colin when he's in. And we'll
Excellent.
see you at another hearing soon.
Excellent. Thank you so much for having us once again. And I'm thinking we're coming up a year of doing this, so I am aiming to come up in person, hopefully before the process finishes. But we'll just see how we go. But thank you again for having us. Really appreciate it.
Okay, thank you.
Thank you. Bye bye.
See them on the subdivision. Okay, so now we have Carbon Neutral New Zealand Trust. Thank you for coming all this way. Well, I suppose it's down the road, but still.
It's not that far, but on the
Good to
way,
see you in person.
and on the way, we considered moving to Kaikohe, so we don't have to travel so far.
Oh, I can relate. Yeah.
You didn't cycle here?
EV.
Okay, so look, we'll hand it over to you. I don't think you pre-submitted evidence to us. You usually present your evidence on
We
the day.
only have to send one photo, but
Yeah.
I don't know whether we need to look at it.
I think what we have with you is you have prepared some written statements, and then you provide them to us afterwards. Yeah, I think we've got a photograph.
Yes.
It's really good.
Yeah.
Okay, does everybody have that photo?
I have got it printed. Do you want me to?
Oh, yeah, we're not hand out a printed one.
You can zoom in on the iPad.
Yeah.
Let's have-
Right, thank you very much. And thank you for the opportunity to address you again at this hearing number 13 on natural hazards. We won't go into paragraphs that need to be changed probably, but it's related to natural hazards. As you know, our charitable community group, Carbon Neutral New Zealand Trust, focuses on climate change awareness and action. Climate change is inextricably linked to natural hazards, and its effects are becoming increasingly severe and frequent. 3 years ago, in our last district plan submission, it's already 3 years ago, we started working 5 years ago on it, we raised significant concerns about numerous risks, including flooding, particularly in flood-prone areas. We argued that housing developments in these areas should be prohibited. While we supported the rezoning of TB Fresh property, we also highlighted the flooding risks associated with it. TB Fresh's application includes mitigation plans, but Tonkin and Taylor's report of 23rd May questions whether these plans are sufficient. During our preparation of the Heritage Waipapa Spatial Plan, we became acutely aware of the extreme flooding risks in Waipapa, especially during weather bombs, events that can bring 300, 400, or even 500 millimeters of rainfall within 24 hours. 5 rivers flow into into Kaikohe, with the Kaikohe and Puketota rivers being the largest. In April this year, we experienced 3 heavy rainfall events up to 100 millimeters of rain, causing mild flooding in some places. These events were a stark reminder of what could happen during more severe weather bombs combined with storms. Such events could cause massive damage and destruction in Waipapa, particularly due to the area of State Highway 10, which has only 3 underdimensioned culverts. Large areas would be impacted, including numerous commercial and industrial buildings that have been built in recent years in this natural flood zone. Those developments exacerbate the problem with their impermeable roofs, parking grounds, and raised building platforms, which act like islands in flood. It's important to know that the NRC's flood risk maps are outdated. The LiDAR maps are expected soon, which will provide more accurate data.
I'll continue. In all of our work on the situation, we have also learned now that the NRC Kaikohe River Catchment Liaison Committee has been working on a flood mitigation plan since 2012. Their proposal includes a K3A dam on the Kaikohe River, approximately 2.5 kilometers upstream from Waipapa, to control the water flow during severe storm events. Control and catch, of course. In 2024, PK Engineering developed an even larger concept, a 110-acre Lake Waipapa on a low-quality, flood-prone paddock farm at the corner of State Highway 10 and Puketota Road. The concept involves digging a lake and using the soil to build a dam. Both the K3A dam and Lake Waipapa concepts include the creation of a large lake to manage water flow with added benefits such as hydroenergy generation, water reserves for townships and irrigation, and recreational opportunities like water sports and aquatic life. These plans have been presented to FNDC, NRC, and MPs, but no action has been taken so far, despite the urgent need to address the tremendous risk. And as we said in the beginning, we started 3 years ago, and it's going to be another 2 years until the PDP is in effect, and the risk is increasing not in a linear way, but basically exponentially. While these flood mitigation plans are not directly part of this hearing, they would have significant impact on the PDP. Once the flooding risks west of State Highway 10 are resolved, more land will become available for the development on the eastern side, particularly the key fresh land, which is essential for the long-term expansion of Kaikohe. For that reason, we strongly supported the inclusion of option F into the spatial plan, which Council agreed last week conditionally. We are aware that the Kiwi Fresh zoning rezoning application will be considered at the hearing in B, but the Tonkin and Taylor report, which also references these and other natural hazards, is enclosed in the documents filed for this hearing 13. As lay people, we cannot judge the best solution for these flooding risks, but we urgently highlight the need for action. We support the precautionary approach outlined in the PDP, but we also believe that the immediate action is needed to address these risks in the planning. Thank you for all the hard work you've done so far and all the considerations. We do appreciate that, even though we might sound as if we oppose
And we appreciate the effort, your submissions.
May I point out the map is based on the last LiDAR map that NRC had arranged, 2009, I think. So it is outdated. The new one is expected, we believe, by August. And the result will have much more blue color, I'm pretty sure, than indicated on this map.
Yes, that may well be the case. Okay, well, thank you. I'm assuming that we'll see you again at hearing 15D.
B, C, and D.
Obviously, hearing 15 is
14.
focused exclusively on the spatial plan area.
Yep.
And so I assume you'll be there presenting further evidence on this matter.
Sure, yes.
Yes.
And it seems to me that a lot of the reference material you had with regards to natural hazards came out of the underlying hazards engineering report that went with the spatial plan.
Yes.
Yeah. Any questions?
Just a statement really about the timing of the new NRC LiDAR. I think you were here when we asked those questions.
By August, we were told at the spatial plan hearing.
We asked the staff earlier about the timing of bringing in updated information from the Northern Regional Council and including that as part of the district plan through a Schedule 1 process. The areas in Kaikohe have had new flood works, as well as Moriwa, I think, is currently having those works undertaken. So there will be a delay, the staff indicated about 2 years' time, before we can bring on that new information, and would have to do a plan change at that time. But we also probably have a new act by that time as well, the new act from central government. So
By that time, Waipapa maybe washed away.
well, in terms of the planning processes, and maybe regional council may be putting in the long-term plan for the new flood mitigation as well between now and then, who knows? Yeah.
I think these concepts need to be looked at seriously. It's obviously not the commissioner's job to do that, but NRC and FNDC really have to get up to speed to look seriously at these plans, especially the PK engineering plan, which PK has created on his own behalf, free of charge. He said it's at least $50,000 worth of work, and there was extensive maps showing even the concept of a botanical garden that might come out of it with huge benefits, tourism and recreation and so on. It's really amazing, but it needs to be looked at seriously. And as we said, we are not in any position to judge which concept will be best, possibly even both together. But something needs to be done urgently.
Thank you. I understand where you're coming from. I guess a philosophical question I've got is these solutions upstream, the dams and the lakes and what have you. Does the fundamental issue is it still there? Like that spatially downstream, what if the dam breaks or something and, the flooding risk is still, shouldn't we be keeping away from these areas? I mean, I don't think I don't want to have an answer.
The water is coming anyway.
Yeah,
it is already coming.
Right.
And the houses and properties are endangered by them. And in the last very serious one, there was even that person killed by the flood. So something needs to be done.
And the water is needed. And we are now in a time of drought and flood.
Right.
And when we have the drought, we need water for irrigation. This is a very important horticultural area as well. And we need that water, and our groundwater level is dropping already. So we need the water. it would be good to have the extra facilities and energy generation possibilities. So the construction of the dams is a different matter, but apparently nowadays it can be done.
But physiologically, as you put the question, if you are doubting the safety of a new dam, then we shouldn't have any dam worldwide. Worldwide. Because you could always expect something. Hopefully, nothing like that will happen. But obviously, the dam needs to be built safely.
I guess my question is more about the downstream areas where it has flooded. Shouldn't we just be keeping away from those long term, just in case something does happen long term, rather than going, well, the dam's fixed it, let's put houses there kind of thing?
Well, there are different downstream areas. When you look at the 5 rivers, it's like 5 fingers, right, coming into that area, and they're all flowing into that inlet. And there is an enormous volume. I mean, we're talking 10 million cubic meters that's coming down. Now you have these, as for Kaikohe River, pretty steep sides. And then you have this floodplain area of what, 120 meters or something. Of course, you shouldn't build anything on 120 meters unless it's pop-up things or whatever. But on the inclines and the flatland, there is a lot of flatland until State Highway 10, for example. You can build, it's all under the flood danger, but that little bit of flood can be mitigated and controlled if you have deep catchment lakes, right? And there's, as a Lake Waipapa has a reserve lake on the side, and the K3A Dam is another reserve lake on the side as well. So you can capture up to 500 mil per day rainfall.
And another point is, just last week, the spatial plan was completed. We were among those who pushed for the inclusion of the so-called option F, which includes already its own flood mitigation project, but as Thompson and Taylor said, may not work, but nobody knows. Specialists have to look at that. That unfortunately is still growing, and it's growing very fast, and that it's running out of space, and the proposals of the council's planners are insufficient. With a little bit of infill in Kaikohe itself, and using more high quality agricultural land, and a little bit more infill in Waipapa, and a little bit expansion will not be sufficient to cover all that growth for Kaikohe. So these 5 rivers that are flowing into the bay here, they are already having this impact of risk. And well, a solution would be Kaikohe's growth would be stopped. But I guess that just doesn't work. Unfortunately, I would prefer it to stop. There has been too much growth already in places which are not good, not suitable, often too far away from the center. So satellite town like the Taps farm, which has just been approved against the wishes of FNDC, but the Environment Court let it go. So we need to do something reasonably for Kaikohe and Waipapa.
Yeah, thank you. And no doubt we'll talk about this further at hearing 15B, but this is kind of a base issue that's related to that. So,
of course, we were not really sure whether this it's a national natural hazard topic. That's why we're here. But obviously, we'll be talking about the zoning later on.
Yeah, thank you. I understand all that. That's good. Appreciate you.
Yeah, thank you. We look forward to seeing you again, but thank you for introducing the issue for us, because that's some more to think about.
And you're welcome to do a deputation to the Northern Regional Council to include flood protection works in their long-term plans.
Yeah, sure.
Yeah.
Hopefully not so long term, but rather short term. But obviously, we need to be realistic. If a dam would ever be built, it'll be 5 years, maybe 10 years down the road.
10 years it took for Kaitai's physical construction and 20 years to get it to the consenting stage. So it's a 30-year project, so
Yeah, makes you sharp.
be good to start now.
Okay, thank you very much
Thank you.
for your attendance and your submissions, and we look forward to seeing you again soon.
Great. Thank you very much.
So,
Thank you.
I think that brings us to the lunch adjournment.
Correct.
Take an hour. Only because we can. I'm sure you want to, you probably don't need that much time, but I'm happy to give you an hour. And we'll come back at 1.
Muting the room and turning off the camera, and I'll stop the recording.
Okay, fine.
It's quick.
City properly.